I'm Vijaya. You're listening to the Immigration Hour with the NPZ Law Group, providing comprehensive US and Canadian immigration legal support to employers, employees, and their families. Joining me is David Nachman, founder and managing attorney at NPZ Law. Welcome, David. Namaste.
Namaste, Adab, Sat Sri Akal, and Kemcho to you and to all our Radio Mirchi listeners, Vijaya.
Thank you, David. And I hear that there's a new B-1 visa classification for individuals who are specialized trainers. Now, what is this new classification and how does it work?
Wow, that's a great question, Vijaya. And, I know in the past that we've been talking about other potential training visas. There is the J1, and there's a subclassification for the J1 for trainees. We've also talked extensively about the H3, which is a training visa, and we can get groups of people, almost 25 people on that type of visa. And there's also what was available at the consulate by way of a separate application called a B1 in lieu of an H3.
So this is corporate training, is it? This is corporate training.
Yeah, this is corporate training. And basically what this did, this is a sort of it was a change that was made to the Foreign Affairs Manual that flew under the radar. And it's now there's a classification which is a B1 for a specialized trainer. So it's a new classification. And it's kind of interesting insofar as it's designed for multinational companies to have a clearer pathway for bringing foreign experts to the United States and transferring specialized knowledge to American workers who are not, of course, performing day-to-day employment, which, we see in visas like the H-1B, the L, the TN, and so on. And it kind of has its genesis in the in what happened in Georgia. You may recall that there was a Korean automobile factory where they had gone in and they noticed that a lot of individuals were on the B1, and so they realized that they needed to create a clearer pathway. And so basically what this is for companies that are operating in either the manufacturing, technology, engineering, or pharmaceutical fields. And there are a couple of elements that we have to be careful to make sure that we, abide by. One is that the individuals have to be on the foreign payroll. They can't be taking U.S. payroll. The individuals are not displacing U.S. workers. The work that they're doing needs to be international in scope, which is somewhat subjective. But essentially what it does is it extends the concept of the B1 classification, which was linked to after-sales contracts. So it kind of takes it away from it needing the knowledge that the individuals are bringing doesn't necessarily need to be linked to an after-sales contract or some type of a piece of equipment. But what it does is it focuses on the individual's specialized knowledge. So it is a new classification. And of course, we are, still in the genesis of being able to figure out how this is going to be applied. But it looks like it presents some very unique opportunities for continuing, and for us, for the lawyers at the NPZ Law Group, as well as for other immigration lawyers across the country, to be able to take advantage of the worldwide brain drain and to bring the best and the brightest to the United States. So essentially, this classification is it's sort of a meaningful shift away from the older B1 framework, where training activities were tied to installation and, as I said, the installation and servicing of sales contracts. And now this new language takes a much broader approach. And so again, the focus is going to be on the individual's expertise and not just the equipment or the contract itself. So of course, I just remind our listeners that if they're thinking about using this classification, paper trails do matter. We, of course, recommend that they think about getting pocket letters or evidence when they go to the consulate looking for this type of a classification. And the way it's going to shake out, at least according to the Foreign Affairs Manual, is that a stamp is going to be placed into the passport which says, quote, B-1 specialized trainer. And so that should be available for 10 years, which is the reciprocity between the United States and India. And then when the individual makes their entry, they'll be able to make it for 6 months and get extensions or to get changes of status.
I see. So very specific parameters there, and
absolutely. But focused on all the right stuff, which is that again, it's designed hopefully to allow us to attract the best and the brightest to the United States. Now, with all the bad news that we're hearing in the immigration realm, it's nice to be able to shed a little good news here.
Yeah.
So,
a little relief right there. I mean, heartening.
Absolutely.
So, thank you for that, David. And resolving the spectrum of US and Canadian business, employment, and family-based immigration for you, that's the NPZ Law Group in New York, New Jersey, Indiana, Canada, Florida, and India. To seek their help today, visit visaserve.com or simply call 201-670-0006 and claim that discount off your consult when you mention Mirchi. More on immigration coming up in just a moment. We'll be right back on Mirchi. It's hot.